Hello everybody, welcome to iExamB. Embrace the iExamB learning experience. We have started discussing previous year questions subject-wise in Phase 1 and Phase 2 exams. In this video, we are going to take questions from Jurisprudence, Interpretation, Administrative Law, Latin Terms and Maxims. We will take up the previous year questions of the 3 years, 2020, 2022 and 2023. This topic is now present in Phase 1 Paper 2 and has a weightage of 20%. That means you can expect somewhere 10 questions and around 10-11 questions came in Phase 1 Paper 2 in 2023 from these areas. So let's start with the questions. The first is, consider the following statement. The purpose the legislature had in mind as to meaning and implication of the words of a statute while framing it. Choose the best option. What does this refer to? Principle of literal interpretation, harmonious construction, legislative intent, justum generis, reasonable construction. The correct answer is C, legislative intent. Legislative intent as such is nothing more than the purpose the legislature had in mind as to the meaning and implication of words of a statute while framing it. In general, the purpose behind framing any statute is either to curb some public evil or effectuate some public benefit. The intention of the legislature is essentially constructed of two aspects, concept of meaning and the concept of purpose and object. This former, the concept of meaning, connotes an understanding derived from the literal meaning of the words of a statute, and the latter points to the spirit and reason pervading through the statute. Question number 2. If any act repeals and reenacts, with or without modification, any provision of a former enactment, then references in any other enactment or in any instrument to the provision so repealed act shall, unless a different intention appears, be construed as reference to the provisions of so repealed act. Unless a different intention appears, be construed as reference to the provision of both repealed and reenacted act. So to which act will it refer to? Will the reference be to the repealed act or to the reenacted act? It's to the reenacted act, be subject to the very context of the enactment, neither the repealed nor the reenacted act, but will be decided by the Supreme Court. The correct answer here is C. It will be referred to the reenacted act. Unless a different intention appears, it will be construed as reference to the provisions of the so-called reenacted act. This is mentioned in General Clauses Act, section number 8. Question number 3 is justum generis is of specified kind, of the same kind, specific not general, general not specific, of particular kind. Answer is B, of the same kind. A justum generis is a secondary or subsidiary rule of interpretation which literally means of the same kind or of the same nature. This is intended to be applied where general words have been used following particular and specific words of the same nature on the established rule of construction that the legislature presumed to use the general words in a restricted sense, that is to say, as belonging to the same genus as the particular and special words. So here, if general words are followed by special words, those general words are given the similar meanings as the specific words. Question number 4. The judges cannot go beyond litera legis is propounded by which rule of interpretation? Golden rule, ordinary meaning rule, mischief, rule of construction, beneficial construction. Correct answer is B, ordinary meaning rule. The literal rule, also known as grammatical, plain meaning or ordinary meaning rule of interpretation, is the rule which propounds that judges cannot go beyond litera legis. It means that law has to be considered as it is. Question number 5. This was in 2023 exam. Thou art to be hanged not for having stolen a horse, but in order that other horses may not be stolen. This is the theme of deterrent theory, doctrine of societal personification, doctrine of correctional vengeance, retributive theory, preventive theory. Correct answer is A, deterrent theory. Deterrent theory of punishment. This term deterrent comes from the word deter, which aims at preventing criminals or individuals from committing the offense of any crime. This keeps in mind that an individual's probability of committing any crime in future is lowered, and it will generate a fear in their minds so that they are aware of the consequences of their criminal act. The idea of deterrent theory of punishment is utopian idea. This can be understood in the words of Dr. Bernard J., who said, "Thou art to be hanged not for having stolen a horse, but in order that other horses may not be stolen." So here the deterrent theory of punishment aims not only at punishing a criminal, but ensuring that the same kind of act is not repeated again in the future. Question number 6. Jurisprudence is a Latin term which means knowledge or study of law, interpretation of law, rule of law, procedure established by law, justice. Correct answer is A, knowledge or study of law. This is also a 2023 question. Word jurisprudence is the English derivation of the Latin word jurisprudentia, and literal meaning is study, knowledge, or skill with regards to law. Question number 7. According to Salmond, jurisprudence is the body of principles recognized and applied by the state in administration of executive, justice, pursuit of justice, enforcement of sanctions, regulation of conduct. Correct answer here is B, administration of justice. We have various theories of jurisprudence given by various theorists. According to Friedman, the law consists of norms of conduct set for a given community and accepted by it as binding by an authority equipped with the power to lay down norms of a degree. According to Duguid, law is essentially a social fact which regulates the conduct of each individual in the community. According to Parker, law is a body of principles enforced and applied by the state through judicial authorities by physical force in pursuit of justice. Coming to Salmond, according to Salmond, law is a body of principles recognized and applied by the state in administration of justice. Question number 8. Subordinate legislation is when Parliament makes procedures to operate itself, Parliament makes laws for working of executive, Parliament delegates lawmaking powers to executive, Parliament does not delegate lawmaking power, Parliament makes laws to regulate the country. Correct answer here is C. Parliament is delegating the lawmaking power to the executive. Subordinate legislation is the process by which the executive is given powers by the primary legislation to make laws in order to implement and administer the requirements of that primary legislation. Such law is the law made by a person or body other than the legislature, but with the legislature's authority. Article 13(3) of the Indian Constitution includes within the definition of law forms of subordinate legislation such as order, rule, regulation, notification. Question number 9. A statute which governs the extent which takes place in future after the statute has came into existence is enabling statute, disabling, retrospective, prospective, future statute. So here this is prospective statute. It is governing the event which will take place in the future after the statute has come into existence. Prospective statute means it can be applied from a future date, while retrospective means the statute is applying from a past date. A law can be considered as prospective when it is appropriate just to cases which will emerge after its authorization. It shows that it is worried about or applying the laws in future, or at least from the date of initiation of the resolution. So these are all the questions that came from jurisprudence, interpretation, administrative law. There have been many questions asked from legal maxims. So we'll move on to discussion of legal maxims now, the questions which have come. Question number 1, the term ab initio means to do away with a problem, removal of theory, gap in a theory, from the beginning, C and D. The correct answer here is D, from the beginning, when something occurred. Ab initio means from the beginning. If a court declares something as a case ab initio, it means that the court's ruling on it applies from when an act occurred or when the circumstances for the case in question were in effect, rather than from the point of time when the court actually ruled on that matter. The term ab initio is used in a lot of circumstances, and you must have heard it most commonly as void ab initio, which means void from the beginning. Question number 2. What is the meaning of the term ad valorem? To annul something, to repeal a law, to add to the value of something, right or ability to get into a property, none of the above. The correct answer is to add to the value of something. Ad valorem is derived from the Latin ad valentium, meaning to the value. It is commonly applied to a tax imposed on the value of property. According to the value, the addition should be done. Question number 3. What is meant by nemo dat quod non habet in law? One can give only what he has or possesses. No proof of damage is required. Burden of proof is on the plaintiff. If he dies, right to sue is gone. None of the above. The correct answer is A. One can give only what he has or possesses. This is a Latin term. The legal rule literally means no one gives what he doesn't have. If a person doesn't have something, how he can give that? That means if he is not the owner of something, how can he pass on the right of that thing? It is equivalent to the civil rule nemo plus juris and alium transferi potest quam ipse habet, which translates to one cannot transfer to another more rights than he has. This rule is associated with the transfer of possession of property in law. Sale of Goods Act and the Indian Contract Act are associated with the underlying provisions of this rule. One can give only that he has. No one can give what he doesn't have. This is what is the meaning of nemo dat quod non habet. Question number 4. What is the meaning of the term amicus curiae? A friend, friend of judge, friend of court, curious judge, both A and C. Correct answer is C, friend of court. Amicus curiae literally means friend of the court, defined as the legal brief when someone who is not a party to the case assists a court by offering information, expertise, or insight that has a bearing on the issues in the case. Question number 5. Amicus curiae refers to friend of court, judge of court, express witness, parties to dispute, none of the above. Correct answer here is A, friend of the court. This legal maxim, amicus curiae, has come multiple times. Amicus curiae means the friend of the court. Question number 6. Which of the following means audi alteram partem? Listen to the other side. Right of fair hearing. Right to obtain a reasoned decision. A and B, all of the above. Correct answer here is D, A and B. Listen to the other side. Right of fair hearing. Audi alteram partem, this principle is the basic concept of the principle of natural justice. This doctrine states that no one shall be condemned unheard. This ensures a fair hearing and fair justice to both the parties. Question number 7. Persona non grata means insane person, person not grateful, wrong person, unacceptable person, unavailable person. Correct answer is D, unacceptable person. Persona non grata means unacceptable or unwelcome person. The maxim has evolved in the area of diplomatic relations. So majorly this is being used in diplomatic relations, which means that a foreign diplomat is unwelcome in that country. In other words, it is a status applied by a host country to foreign diplomats to remove their protection by diplomatic immunity from arrest and other normal kinds of prosecution. Under Article 9 of the Vienna Convention on Diplomatic Relations, a receiving state may, at any time and without having to explain its decision, declare any member of a diplomatic staff persona non grata. A person so declared is considered unacceptable and is usually recalled to his or her home nation. If not recalled, the receiving state may refuse to recognize the person concerned as a member of the mission. Question number 8. Ejusdem generis is. We have already discussed ejusdem generis once in the rules of interpretation. The question on ejusdem generis have come multiple times in all the 3 years. So you will find one question on ejusdem generis asked every time. Ejusdem generis is of specified kind, of the same kind, specific not general, general not specific, of particular kind. Correct answer is B, of the same kind. Ejusdem generis is secondary or subsidiary rule of interpretation, which literally means of the same kind or same nature. The rule is intended to be applied where general words have been used following particular or specific words of the same nature on the established rule of construction that legislature presume to use the general words in a restricted sense, that is to say as belonging to the same genus as the particular and specific words. Question 9. Consensus ad idem means same idea, consent on same idea, meeting of the minds, same opinion on contract, similar consent on contract terms. Correct answer here is C, meeting of the minds. This has come from Indian Contract Act. Consensus ad idem means meeting of the minds. It is mostly used in contract law and refers to the fact that there is an agreement among the parties to the contract. It simply means that there exists a mutual agreement, a meeting of the minds of all the parties to the contract. Question 10. Which of the following terms is related to friend of the court? So this question has again repeated. This time you have the meaning in the question. Amicus curiae, ejusdem generis, bona fide, actuari, incumbent, ad hominem. The correct answer is A, amicus curiae. Amicus curiae means friend of the court. He is an impartial advisor to the court of law. Question number 11. The Latin term obiter dicta means things said specifically, things said by the way, specific order declared by the court, obligation dictated by the court, dictation given by the court. Correct answer is B, things are said by the way. Obiter dicta is a Latin word which means things said by the way. These are observations by the judge or court about a point of law which may be interesting but do not form part of the decision in the case. An obiter dictum does not have precedential value and is not binding on other courts. Question number 12. The term corpus delicti means body of the crime, deceased person's body, decomposed body, criminal decision, decision based on corpse. The correct answer is A, body of the crime. Corpus delicti is a Latin term meaning body of the crime. It is the essential fact that proves that a crime has been committed. The doctrine of corpus delicti is the requirement that the state prove that a crime has been committed prior to allowing a confession to be admitted into evidence. Question number 13. Which of the following term describes infringement or violation of legal private right of any person without any actual loss or damage? So here you can see this question belongs to legal maxim also and law of torts also. So here this is damnum sign injuria, injuria sign damnum, volentin non-fit injuria, actus de nemitti facet injurium, ex injuria jus non auditur. Correct answer is B, injuria sign damnum. So this means that there is infringement or violation of legal private right without any damage. There is injury without damage. Question number 14. When a list of specific words are being followed by general words, the general words are interpreted in a way dashed to the specific words. Options are mutatis mutandis, ejusdem generis, non obstante, ratio decidendi, obiter dictum. Correct answer is B, ejusdem generis. So here it is said there are specific words being followed by general words. General words will be interpreted ejusdem generis to the specific words. So question on ejusdem generis came again. Ejusdem generis, this doctrine is applied when there are some specific words which are being followed by general words. So these were all the questions that have come from legal maxims. Many questions have come from legal maxims over the past years, so be prepared with this topic. You can download all the previous year papers from our website free of cost, and you can also attempt these tests to check out how much you are scoring in these various previous year papers. That's all for now. In 2023 recruitment, 12 of our students got selected. So if you're interested in any form of guidance, in any form of preparation material, you can check out our courses. If you have any doubts, you can reach out to us on this number or you can mention that in the comment below. We at iExamB help you prepare 50% faster with a crisp and concise content. Subscribe to our channel. Stay tuned. Thank you.